To make you the smartest person in the room, we're going to have to talk about this Judge Juan Marchand decision to sentence Donald Trump on January 10th, 2025, 10 days before he's to be sworn in as the next president of the United States on January 20th. Well, I know this is crazy. This lawfare keeps on going, but you need to understand the basics of what's going on here to be the smartest person in the room. And as we've talked about before, to really defend the Second Amendment and our Constitution, you have to have a great understanding of the entire tapestry of the American legal system. And talk about Judge Juan Marchand and the mistakes he's making to get Trump helps you understand the system. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist for the 2025 Gundy's Award in the category of Top Voices of the 2A, Top Voices of the Second Amendment. Thank you all for voting for me and showing your support. We had a lot of stiff competition, a lot of channels out there, much, much bigger than my channel here at the Four Boxes Diner, and yet we were able to punch above our weight and get into the top 5 yet again for Top Voices of the 2A, and we'll see who wins it at the end of January. It'll be very exciting out there in Las Vegas, but again, I appreciate your support as I always have and always will. Okay, folks, so here's the story. As you know, the lawfare engaged against Donald Trump has been a travesty of justice for the last several years, and President Trump has rightly defeated almost all of these nonsense cases, both in the federal level and the state level. But there's one absurd case remaining that we want to talk about because it's still out there and it remains equally stupid. And that is a case that I've talked a lot about on Fox News and on the Fox Business Channel with Maria Bartiromo. That is the Juan Marchand case, the Judge Marchand case in New York State Supreme Court dealing with alleged bookkeeping crimes. This has got to be the dumbest theory out there. Now, just to jog your memory as to how dumb this case really is, the claim is that Donald Trump paid Stormy Daniels a fee or a amount of money of $130,000 in exchange for her signing releases and a non-disclosure agreement. This is really straightforward. Virtually all businesses in the New York area, all across the country, realistically, have these kinds of deals with former business partners or former employees or staffers or whomever. This is a very routine situation to pay somebody money in exchange for mutual releases and the signing of some sort of confidentiality agreement or non-disclosure agreement. It's like right down the middle. Every lawyer in America has basically done one of these deals. This is about as routine as they come in terms of contracts that one would see in the practice of law at all levels of American society, not just the elite levels of New York City. Now, with that context placed, the deal is, and this is the argument was that Stormy Daniels and Donald Trump entered into this agreement sometime in the fall of 2016 at the very end of the 2016 presidential election. As you know, in November 2016, President Trump defeated Hillary Clinton and was sworn into office in 2017. And that's particularly important, what I just said. The election was in 2016. He was sworn into office in 2017. And the reason why that's important is that the payment was made to Stormy Daniels in the fall of 2016, just a month or two before the November 2016 election. That's particularly important. Why? Because we're going to get to that in a second in terms of how campaign finance reporting would work if this were a campaign finance expense. Now, to step back for a moment, the argument is advanced by Alvin Bragg, the same district attorney that went after Daniel Penny, the former U.S. Marine who saved those people on the subway from an attacker, right? This is the same district attorney, Alvin Bragg, that went after him, also went after Donald Trump in this case. Now, here's the thing. Under New York law, if you commit bookkeeping, if you intentionally commit bookkeeping errors, whatever that is, misleading bookkeeping entries, each entry is a misdemeanor. Did you hear what I just said? It's a misdemeanor. Now, the thing is that the argument that Alvin Bragg's office made using a former Biden Department of Justice official that left the federal government to come back to work for the district attorney's office in Manhattan And bear in mind that there's like 3,000 counties in the United States. 3,000 counties in the United States. One of those some odd thousands of counties in the United States is Manhattan. And Alvin Bragg is a county district attorney. So to put that in perspective, this is a single county prosecutor. Yes, it's Manhattan. Yes, it's a famous place. Yes, it's an elite place. It's all true. But the reality is it's just one county. One county district attorney did this or brought this charge against Donald Trump and claimed, and here's the key, claimed that these 34 entries into the bookkeeping records of Trump's businesses that reflected the payment to Stormy Daniels were misleading because they really weren't payments, they weren't legal fees, they were something else. But they were legal fees in that they were paid to the lawyer, Michael Cohen, who settled this case on behalf of President Trump. So they were essentially legal fees or legal related. And that, of course, all this assumes that Donald Trump even knows how bookkeeping works. If you think a billionaire is paying attention to QuickBooks or a bookkeeping system handled by his accountants, I'm telling you that's almost certainly not the case. Why would Donald Trump get into the bookkeeping programs of his companies down at that level? That's way below his job, right? That's below what he does to deal with QuickBooks or bookkeeping entries. Nevertheless, the argument was these 34 bookkeeping entries in Trump's books, these books and records, were misleading. They were not legal expenses. They were really settlement payments, and somehow these are different. Now, under New York law, the statute of limitations for this criminal charge of misleading bookkeeping entries had expired because the misdemeanor date or the statute of limitations for misdemeanor was X dates. It had already expired. So how did Alvin Bragg basically contort the law with the help of the state court judge Juan Marchand, who had donated private money? He had donated in 2020 to the presidential campaign of Joe Biden. Judge Marchand had donated money to the presidential campaign of Joe Biden in 2020. So between Judge Marchand, the judge in this case, and Alvin Bragg, the district attorney, and a former Department of Justice lawyer arguing the case on behalf of Alvin Bragg, they argued that this was not a misdemeanor case. Even though the bookkeeping errors or the alleged bookkeeping misleading entries were arguably just misdemeanors, they argued that these were actually felonies. And therefore, because the statute of limitation for felonies under New York law is longer than the statute of limitations for misdemeanors for this kind of crime, the argument was that the bookkeeping errors, the bookkeeping misleading entries, were all about hiding or concealing from the public felonious criminal conduct conducted somewhere else or occurring somewhere else. And that these bookkeeping entries were not crimes in and of themselves. They were crimes covering up other crimes. And what the other crimes were suggested to be were federal campaign law violations on the theory that Donald Trump was entering these misleading bookkeeping entries, 34 misleading bookkeeping entries, designed to keep from the American public what is effectively a campaign contribution, or a campaign expense, I should say, by covering up Stormy Daniels' allegations and, tell her to keep quiet. And because, according to the theory, it was a federal crime to not report this campaign payment, this campaign expense to Stormy Daniels to keep her quiet by entering into the non-disclosure agreement, the 34 bookkeeping errors, the 34 bookkeeping entries that were erroneous, allegedly, were all about covering up a federal campaign finance reporting requirement that by doing so would be a crime. And in extension, by virtue of covering up this information, by not disclosing the payment of Stormy Daniels on the list of campaign expenses for the Donald Trump for President campaign in 2016, that was a federal crime, and these bookkeeping entries were designed to conceal the federal crime, and by extension, because they were designed to conceal a federal crime, they were not charged as misdemeanors, because the statute of limitation had already expired for misdemeanors and they couldn't be charged. Instead, these bookkeeping entries, because they were connected to covering up another crime, were actually felonious. They were actually felonies. And because the felony statute of limitations in New York is longer than the misdemeanor statute of limitations in New York, the felony statute of limitations had not yet expired. And therefore, Alvin Bragg was able to charge Donald Trump for a felony for these bookkeeping records based on the theory that they were about concealing or covering up federal campaign crimes. Despite the fact that the federal campaign commission, that the Federal Elections Commission, the FEC, had looked at these transactions and concluded that Donald Trump and his campaign team had not violated federal law. Nevertheless, Alvin Bragg took the position that it doesn't matter that the federal experts on campaign finance law and that the Attorney General of the United States, who is the expert and is supposed to be enforcing federal campaign finance laws, said there was no problem here. Alvin Bragg said a New York jury in one county in New York, one county in the country, could go out there and disagree with the FEC and with Attorney General Merrick Garland, who obviously is no fan of Donald Trump, as you've seen from this channel. So, of course, what goes on there is Juan Marchand allows this case to proceed, and a group of 12 jurors from New York City find Donald Trump guilty of all this. Now, one of the problems here, of course, is that Juan Marchand, the judge, specifically told the jury that they did not have to agree upon that there was some other crime committed that Donald Trump was concealing. He basically said to them that you don't have to agree unanimously on the particular specific crime that Donald Trump had elsewhere committed that was being covered up by these bookkeeping entries. That each of the 12 jurors could conclude in their own opinion about the crime that Donald Trump was trying to cover up with these bookkeeping entries, which meant that juror number 1, for example, could have concluded in his or her mind that Donald Trump was trying to cover up a campaign finance violation. And jury number 2 could have concluded that the bookkeeping entries were about covering up a different sort of crime. And juror number 3 could have concluded that these bookkeeping entries were about covering up yet another type of crime. And none of those 12 jurors had to even agree on what that other crime was that was being covered up by the 34 alleged bookkeeping errors. And of course, under due process law, under basic constitutional law, you have to have a unanimous jury agree unanimously with every single element of a crime before you can be convicted. And since an essential element of crime here was that Donald Trump was covering up some other crime, there had to be a unanimous agreement that there was another crime committed. Each of the elements had to be proven to be committed unanimously, and then you also had to show that every entry of these 34 entries was improper. But because the jury never agreed as to what this other crime that was allegedly being covered up was, you don't have a unanimous agreement under the due process clause, and you have to throw the verdict out. But Judge Marchand refuses to do so. But beyond that, there was an easy way out for Judge Marchand, but he did not decide to take it. That was, if you remember, the jury verdict against President Trump was in the spring of 2024. What happened shortly thereafter was the United States Supreme Court, in the presidential immunity case arising out of Jack Smith's work, had found that Donald Trump, in his official capacity as president, was immune from various criminal activity because you can't charge. There's a presidential immunity that prevents the president from being charged with crimes while he's acting in his official capacity as president. And by extension, you're not allowed to use evidence during his time as president while he's acting officially as president as a basis to go convict him of a crime. And because Judge Juan Marchand, in this case involving the bookkeeping entries, allowed into evidence information about Donald Trump's work in his official capacity as president while he was president, and allowed that evidence and testimony about that time while he was president and his work as president into evidence for the jury to consider. The jury was allowed to consider improperly evidence that should have been excluded on the grounds that that evidence arose from Donald Trump's time as president, acting officially as president, and thus that evidence is immunity, is not allowed in, cannot be considered. And yet it was considered by the jury because Judge Juan Marchand let it in. And what he should have done, in my opinion, and I've said this on Fox News and elsewhere, is Judge Marchand should have used this opportunity to save face, to say that the jury verdict was improper because it considered evidence from when Donald Trump was president. And because he now had the benefit of the Supreme Court's decision, which he did not previously have, he could have then said that the jury verdict was tainted and the case has to be retried without the use of that evidence of Donald Trump as president coming in. That is what he should have done, because he would have had a good excuse to say that when I decided what I allowed in, I did not have the benefit of the Supreme Court decision, which came out after the verdict was rendered. So it would have been a perfect opportunity, in my opinion, for Judge Marchand to save face, to vacate the jury verdict with a very good excuse to say, had I known of the Supreme Court decision before I made these rulings, I would have gotten it right, but I didn't have the benefit of it. Now I understand it. Now I realize the jury verdict is tainted. It has to be vacated and redone. That was the right decision by Judge Marchand. He didn't take it, though. So with all that said, what's happening now? So Judge Marchand has just said that he's going to sentence Donald Trump on January 10th. Now, he's indicated he's not going to send Donald Trump to prison. Well, he shouldn't, because it's a stupid case, and the case should not even be brought. Nevertheless, here's what the tension is. You're going to watch this carefully. Because Donald Trump has an argument that his presidential immunity was violated by the use of the evidence at trial involving immunized evidence, meaning his evidence that he was acted when he was acting as president, that came into evidence, he could take an immediate appeal before January 10th, and by doing so, he will almost certainly stay the ability of Judge Marchand to act, because by taking the appeal, he's going to divest Judge Marchand of jurisdiction over the case. So Donald Trump, if I were Donald Trump's lawyer, I would probably be looking to take an immediate appeal before January 10th to divest Judge Marchand from jurisdiction so Judge Marchand cannot sentence me. That's one approach. The other approach is this, that he could allow Judge Marchand to sentence him formally on January 10th. And that will likely be some sort of a conditionary probation or conditional discharge or some other nonsense. Maybe there'll be a small fine, I don't know. But whatever it is, it's going to be de minimis, and it won't include prison. But that will allow the left to say that Donald Trump is fully 100% a convicted felon when he takes office. So Donald Trump may not want that, which is why he may want to take an immediate appeal involving the immunity, or he may allow for the sentence to take place, the sentencing to take place, and then he will take an appeal saying that this jury verdict is nonsense and has to be vacated. It's my prediction that when an appellate court looks at what Judge Marchand did here, not only with the immunized evidence that never should have come in because it covered Donald Trump's time as president, but also the fact that he allowed a verdict to occur without the jury agreeing unanimously as to what the crime was that was being covered up. Moreover, as a matter of just factual, think about it. And remember, I told you there was a key distinction between 2016 and 2017. If you want to assume that federal campaign finance law could even be handled by the state attorney here, by Alvin Bragg, think about it for one moment. Why it's impossible for Donald Trump to be convicted. Impossible, as a matter of fact. I believe the money came either out of President Trump's personal accounts or his business accounts, but whatever it was, it did not come out of the donations made to the campaign. But even if you want to assume for the sake of argument that the Trump campaign paid this off to Stormy Daniels in the fall of 2016, listen carefully, folks. When would the public disclosure have been made to the public about this expense? The answer is it would have been made sometime at the end of 2016 or in early 2017 after Election Day 2016. Hear what I just said? Even if you assume arguendo that this was a campaign expense to paying Stormy Daniels off to enter into a non-disclosure agreement, the time to disclose that would have been after the 2016 election, which meant that it would not have impacted one way or another the voting on that day in 2016, because it didn't even have to be publicly made available until 2017 when the reports were due with the FEC. So even if it had to be disclosed, which it didn't, because again, the FEC, the federal officials involving with this, looked at this and it didn't have to be disclosed, and no one charged Trump or fined him or anything. Even if you assume it had to be disclosed, it would not have been disclosed until after the election, which means what? Which means that the argument that Donald Trump's bookkeeping errors with the goal of hiding this from the American public so he could win the 2016 election could not possibly be true, because the earliest these bookkeeping entries and the disclosure would be made to the public would have been in 2017 after the election. So you cannot possibly have a causal connection between hiding the bookkeeping entries, illegal bookkeeping entries, and hiding this information and hiding these expenses from the American public and trying to influence the voting in early 2016 when the November 2016 election occurred, because none of this stuff legally had to be made public until months thereafter. So even factually, even if the entire legal theory held up, factually, it's simply impossible to argue that these bookkeeping errors, these bookkeeping entries, these 34 felony counts of 34 bookkeeping errors could not possibly be causally connected to any detrimental reliance or misleading or fraud or deception or hiding or omissions or anything with the American public, because they never had to be made publicly available until 2017, literally months after they would be relevant, i.e. at the time of the 2016 election. Despite everything I just said in this video, Judge Juan Marchand, the guy that donated money to the Joe Biden's campaign in 2020, is going to sentence Donald Trump for this crime on January 10, 2025, 10 days before the presidential election. But a lot can happen between now and then, and could happen between January 10th and January 20th. But this is a nonsense case. I don't see any way on earth this is ultimately upheld over time and can possibly survive the appellate process. Nevertheless, it has given the left, it has given the anti-Trumpers really public relation fodder, marketing talking points, anti-Trump talking points to talk about for the last 6+ months, and they're still using the convicted felony nonsense when all of this stuff, in my opinion, is hooey. But nevertheless, it's very important for you to kind of understand what's going on, because by teaching you these things, I think it's making you a smarter consumer of information about the legal system and how judges or prosecutors work and how games can be played, because the smarter you are about the legal system in total, the smarter you will be in defending all of our constitutional rights, including the right to keep and bear arms. Because remember, the entire Constitution works together to protect our liberties as American citizens against the over-encroachment and the tyranny of an overreaching government, whether it be state, local, or federal government officials. And again, the Constitution is very important, which is why all elected officials swear an oath to the Constitution and make that the ultimate law of the land. And anything that contradicts it cannot be enforced. Okay? Well, there you have it, folks. Hope you learned a little bit something here today. Make sure you follow me on X at @ForBoxDiner. Don't forget to like this video and subscribe. We're trying to get to 200,000 subscribers, and I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.